Remember, Mr. Glogow has constantly relied upon the 1997 testimony claiming 2-inch mesh nets wouldn't produce unnecessary killing and waste. How about some more insanity?
Those tests, the information that was gleaned from those tests was exactly what the agency expected. They knew that the 3-inch net would gill legal-sized fish, and they knew that the 2-inch net was going to gill undersized fish.
If the FWC knew exactly how the net tests would turn out, why then are they still defending a known lie? Why do they claim we staged pictures of nets full of juvenile fish? And why did they even have to conduct tests in the first place, if they knew exactly what the results would be? Finally, why we've been ridiculed for the last decade for being truthful. In addition, we feel Mr. Glogow owes the fishing industry an apology for telling the Senate that we were staging pictures of 2-inch mesh nets full of juvenile fish. Here's what the case boils down to. Listen carefully.
Your Honor, that's the key thing here. This has been litigated. It was litigated in 1997.
Or let me ask you right there, has it ever been litigated that the 2-inch mesh is illegal, as they're saying today? Has it ever been litigated in that respect?
Well, what was litigated was whether the choice of 2 inches was reasonable and not arbitrary and capricious. And it was found that it was, and this court affirmed that decision. This court affirmed that decision and said the 2-inch mesh rule, the same rule. It is the affidavits that we presented from Julie Jones, who's a colonel in the Marine Patrol. The rule is exactly what it was back then, 2-inch mesh. And that was what was being tested in the administrative proceeding. The administrative proceeding was found that that net rule complied with Section 370.025. It complied. They made, the plaintiffs in that case, Your Honor, made exactly the same claim that they're making here. Paragraph 65, the hearing officer says, petitioners challenge the proposed rule because it will allegedly cause unnecessary killing, overfishing, and waste of juvenile fish. That is exactly what they're saying today, and she discounted that. She said that's not correct. The rule is valid.
Anyone with half a brain would ask, how could the FWC prevail in court for the last decade using such absurdity? Here's how they prevail.
If we've not shown sufficient evidence to go to an evidentiary hearing to establish that, we never will.
Isn't this something that the trial judge should hear at an evidentiary hearing rather than on summary judgment? That's sort of what bothers me now, how the trial judge could decide all these things on a summary judgment and not have an evidentiary hearing.
It's not for the court to debate the wisdom of the legislative determination, or in this case, quasi-legislative determination.
Well, let me ask you this, Counselor. Can your commission just do anything and we have no supervision over it, even if it's totally unreasonable, which Mr. Rudlow says it is?
No, it's not
totally. Well, it is a question here where we draw the line in the courts as to whether a rational basis is presented or not.
If the agency presents a rational basis for the rule on the record, then that's all they have to do. If the agency presents a rational basis for the rule on the record, then that's all they have to do.
This, whatever they think they are, this constitutional unknown over here agency that suggests basically, and I think the court kind of felt like nothing I can really do, if they say there is a basis, I kind of have to accept it. We don't agree with that. We're entitled to some due process here.
We are entitled to constitutional due process as guaranteed by the federal and state constitutions. But until there is constitutional due process, the truth and facts, as you've seen in this case, will not matter. The FWC legal staff are responsible for our lack of constitutional due process. With constitutional due process, or staff attorneys that understood what the Supreme Court meant by harmonizing the amendment, this net problem would have been solved a decade ago. The first DCA Chief Judge's opinion of the FWC, imperious. If agencies are not required to justify their alleged rational basis when that basis is refuted, as here, this court is preparing a fertile field for the growth of imperious agencies with all the mischief it entails. A little more about the staff's efforts pertaining to the net issue. The FWC staff held 2 net meetings for top members of industry and Ted Forsgren of the CCA. The meetings were held on 2 separate days. In a 12-to-1 vote, fishermen accepted increased fines and penalties, only if the net problem was fixed. The staff informed the legislature that if they passed increased fines and penalties against fishermen, that they would fix the net problem. The bill was passed and signed into law. But once again, as they have every other time, the staff dealt with us in bad faith. The staff lied to our legislators about fixing the net problem. The legislature and the fishermen got the staff shaft. Representative Kendrick chastised the commission for misleading him about fixing the net problem at a commission meeting in St. Petersburg. Listen to FWC Commander Colonel Julie Jones apologize about 2 of the bad faith net meetings the FWC's conducted over the last decade.
And I think we got off on a really bad footing with the first set of meetings that we had, that Jackie Falls called, and the voting. There's you notice this is your technical group. First of all, I think you see that this is only commercial fishers. First of all, so this is not a matter of voting or doing anything like that. I apologize for what happened in those first few meetings because it was misleading because it seemed like you were going to get a product out of it, and obviously you didn't get that product out of it. But having said all of that, the second place where we have failed you is in trying to accommodate the legal requirements pushed to us from several states' attorneys to put into rule how to measure a net and do some of those things. When we took up the gear rule, we told you at every turn that 2-inch stretch mesh was not a part of that consideration. We were taking that part of the rule and putting it in not making changes. And I really wanted to push that decision-making to the commission and not be a part of that gear rule. And, of course, the train jumped the track there, and it just seemed like we were ignoring you at every turn. So my apologies. We've obviously gotten off on the wrong foot, and let's hope that this group, that does not happen again.
But as it has for the last 10 years, it happened again. The staff canceled the net test and claimed that we caused the test to be canceled by filing a lawsuit. We are angry at the staff's years of bad faith, deception, lying to the public and the legislature. It's long past time for the commission to not only fix the net issue, but to clean house. For the sake of brevity, we will trust that the commission knows that we have always backed up what we claim and that we have far more proof of the staff's mischief. The legislature must never again make the same mistake of leaving the creation of constitutional due process in the hands of a constitutional body. Absolute power corrupts. Part 2. The benefits of variable mesh rectangular nets. The FWC staff have admitted that you have the authority to amend the gear rule. Benefits for the environment. 98% bycatch will be reduced to 3% bycatch. Every fish will have an opportunity to spawn at least once before being captured. More spawning fish equal more food for sports fish and more adult mullet in the future. We estimate that the variable mesh size will enhance sports fishing by at least 33%. Benefits for the economy. Variable mesh sizes will provide limited relief to the fisheries and industries dependent upon the fisheries, such as local restaurants, struggling fish markets, and sports fishing. Benefits for the citizens. The return of availability of traditional low-cost seafood for the minority consumer will allow older fishermen that are unable to throw a commercial cast net to legally catch fish and experience limited financial relief. May help save the livelihoods of the few fishery workers left in the net-related business. Will help curb poaching and arrest of those with no other means to survive. And we haven't forgot about how this may benefit the FWC. It's an opportunity to begin a new era of cooperation and trust, which might lead to us letting up in the legislature. Maybe in the future we can work together. Wouldn't that be nice? For more information, visit fishingforfreedom.net. Questions? Contact David Grix, email at fffsouth@aol.com. May God bless the Commission and grant them wisdom to make the proper choice for the environment, economy, and citizens.